Welcome to this briefing of the Jerusalem Press Club, JPC, one of the series Israel Under Fire, which we have been running since the beginning of this operation. I'd like to thank my colleagues at JPC, Talia Deker and Rachel Exil, for facilitating it. I'd like to welcome our guest today, Daniel Reisner. I'd like all of you to remain on mute and ask through the chat, and I'll ask Daniel Reisner your questions. Daniel Reisner is a colonel in the reserves of the IDF, former head of the Israel Defense Forces International Law Department. His capacity was a senior lawyer responsible for advising the Israeli leadership on a wide variety of international law-related issues. Parallel to his professional career, Daniel has been active in the academic sphere as well, teaches in some of the leading academic institutions in Israel, has published articles on a variety of issues, and is a highly sought after lecturer, panelist, both in Israel and abroad. He's a partner at the Herzog Fox Neiman law firm. Daniel, thanks for joining us. Why don't you start with a brief introduction in which perhaps you want to add more details to your rich biography, and also give us a intro into the situation.
Okay, thank you very much, Uri, and good morning, everyone. I can't see any faces, so I will assume you are there.
Yes, they are.
Okay. So to add on to Uri's kind introduction, I have been fortunate enough to have had, I think, 3 careers until now. So I was military for over 20 years, and of those 20 years, 10 of them I was head of the International Law Department of the IDF, which will be obviously very relevant, I assume, to some of the questions we will be discussing this morning. My second career was also about 20 years. I spent 20 years as the Israeli Prime Minister's lawyer for the peace process. So I had the privilege of working with all prime ministers from the late Yitzhak Rabin until the third reincarnation of Benjamin Netanyahu. I did that from 1994 until 2014. And I was very privileged to be the lawyer for the peace process with Jordan. I did 20 years of Palestinians. I did some Syria and Lebanon. In other words, some were successful like Jordan, some were not successful like Palestinians and Syrians, but those were another 20 years of my life. And for the last 17 years, I've been in combination of private practice and academia, where I work as a senior partner at one of Israel's biggest law firms, and I specialize in international law and national security issues and international trade. Now, that as a background, I think should allow you to understand that I have a background both in counterterrorism and the peace process. And I'm fortunate in that respect that I've been able to both fight with the Palestinians and negotiate with them for many, many years. And with that background, I want just to make sure we share the same language. I am an international lawyer by profession. And as an international lawyer, I just want to make sure that some of the basic principles are easily understood before we get to your question. Issue number 1 is self-defense. When you are attacked, you have the right to defend yourself in real life and in international law. But one of the things people do not understand that self-defense in international law can trigger 2 different types of responses. It can trigger a single retaliatory response. So for example, we see a lot of that along the India-Pakistan border when one side shells the other, so the other side shells them back or something. And there are rules about how that response can be made. But another thing which self-defense can trigger, if it goes beyond a certain threshold, it can trigger a war. In other words, if you are attacked, sometimes a war emerges. And when a war emerges, there are totally different rules about the response and what you're allowed to do than if it's just a single response. So that is self-defense. I just wanted to throw that out because most people don't know what that is. The second thing I want to talk about is targeting. When you fight someone, you are only allowed to target military targets. But the term military target is also one of those misunderstood terms, because most people assume that the military target has to be a military target, in meaning it has to be used by a military organization. It has to include soldiers, etc. International law does not say that. International law identifies the military target as a target which there is a military advantage to resulting from its nature, location, purpose, or use. In other words, theoretically, and I'm not addressing anything specific to Gaza, if there is a hilltop, which is a strategic location in a battlefield, that hilltop can be a military target, even if there is no military force, there are no military forces there. So again, I say that because you're only allowed to target military targets in warfare, but most people don't understand that the term military targets in warfare is actually quite wide. The third thing I want to mention to you is the principle of proportionality. And again, this is a term which is totally misunderstood. And because you are working in this field, it's crucial that you understand. Most people think that proportionality in warfare means that if someone attacks you with 2 bombs, you're only allowed to respond with a few bombs yourself. That's rubbish. There is no such rule in international law. If someone throws 3 bombs at you, you can throw 3,000 bombs back. That's not the issue of proportionality. What proportionality deals with is a very specific question. And the question goes like this. When you attack a legitimate target, which has to be a military objective, using legitimate weapons, which is a separate issue, which I don't think is relevant for us today, but etc., you must ascertain that the expected military advantage resulting from the attack outweighs the expected damage, injury, and casualties of civilians. Now, this is one of those really difficult rules of international law because it actually balances between apples and oranges. On the one hand, you have expected military advantage. On the other hand, you have expected civilian casualties. And somehow you're supposed to balance them without a mathematical formula which tells you how to do that balancing act. Now, sometimes it's easy. I'll give you an example. Let's say there's one enemy soldier, regular enemy soldier, surrounded by 1,000 civilians. Then obviously, unless you have a way just to hit that enemy soldier who is a legitimate target, you can't attack. The other extreme is equally easy. Let's say you have 1,000 soldiers and 1 civilian in the middle of them. Then obviously you can attack the 1,000 soldiers. That is the easy case of proportionality. Obviously, proportionality becomes much more complicated. I'll give you an example. Let's say there are 20 civilians surrounding the enemy commander. What do you do now? How do you balance between the military advantage and the civilian casualty? And the short answer is no one knows. There's no real formula for this. And international law does not provide a clear guidance on how to do this. Now, I used to do this for a living. I used to instruct the IDF on the implementation of this rule. And because the rule itself is unclear, you need to come up with your internal guidelines of what is and is not acceptable. So I needed you to understand, however, that the rule of proportionality does not mean that there will not be incidental damage. No one expects that in warfare. It's just that the incidental damage cannot outweigh the military advantage, whatever that means. And the final point I wanted to put on the table, and then I'm quite sure you have questions, is that there is no principle of reciprocity in laws of war. In other words, if one side violates the laws of war and commits war crimes, it does not release you from the obligation to continue to comply. And therefore, those people who say, if someone does A, then I will do B, that's not what the law allows you to do. You have to comply with the law irrespective of how the other side is acting. Sometimes it may not be easy, it may make you angry, but that is what the law says. So I wanted this 4 concept, short introduction to create a common language between us when we start dealing with your questions. But instead of me speaking, let me just say something technical. I am not in active duty. I retired from the Army 17 years ago. But you need to understand, I set up the IDF structure for legal support for military operations. So under my watch, we started injecting lawyers into the targeting process and approving targets for attack. And I was the lawyer who approved the policy of targeted killing. So I have a lot of responsibility in that many of the things that you see today vis-a-vis the legal side were developed during my period in office. And finally, I did call my friends in the Army to ask some questions and get some answers myself before I took this call, so I wouldn't make a total fool of myself. So
thank you, Daniel. Thank you, Daniel. So you see, like everything else in Israel, people retire, but they're still involved and informed of what's going on. So now we established the terms of reference. Let's talk about what's going on in Gaza. I think you once said that the rules of international law applying to warfare were drafted after World War II when armies fought armies. This is not the case now when we have asymmetrical wars and the enemy lures you into fighting among civilians. So is international law outdated on this sphere?
okay, so I want to separate three issues which arise from your excellent question, Uri. Issue number one is international law was originally developed to address state versus state conflicts. So the assumption was that there would be an army on one side and an army on the other side. Because of that, international law also does not allow non-armies to participate in warfare except under very strict limitations. So in effect, any non-army, and an army is a military organization of a state, just to make sure that we understand what an army is. Any person who is not a member of an army who takes part in fighting almost automatically is committing a war crime, just by picking up a weapon, irrespective of what they do with it. And they automatically become a legitimate target for such time as they're doing so. So the first point, I think, deriving from your question, is that the rules were originally intended for state versus state conflict. The second thing is that the rules were originally assumed to apply to battlefields. In other words, there would be an army encountering an army in a valley or in a wood or something. However, life became much more complicated, even in World War II, when the fighting took place within the civilian population. And that is where all of these complicated rules of, for example, proportionality came up, because everyone realized that when you're fighting in Stalingrad, the idea of not having civilian casualties is rubbish. The idea is you have to minimize them, but no one can expect an army to fight in a civilian population without there being civilian casualties. That's why international law does not expect that. Now, I say that, however, that the Israeli-Palestinian conflict, and specifically the conflict with Hamas, has raised several new type of challenges which international law actually did not anticipate, Uri. And I'll give a few examples. Some of them, let's take shielding, for example. Shielding is a war crime. So placing a military-capable device in the middle of the civilian population intentionally in order to make it more difficult to hit it without killing civilians is a war crime. Just by placing it there, not just by shooting it. Now, international law is clear on this subject, but this has become much more pronounced with the Israeli-Palestinian conflict in Gaza. Another example is tunnels. International law has no specific rules for tunnels, yet once we encountered tunnels, we encountered some really difficult questions. I'll give you an example. You don't know who is in a tunnel because by its nature, a tunnel is hidden and secret. So how do you do proportionality when you attack a tunnel if you don't know who's inside? Do you give the attacker the full advantage of saying, unless I have 100% accurate information about who's in the tunnel, I cannot attack? Or can you attack the tunnel assuming that only soldiers and terrorists are inside it? So this created a new type of dilemma. Then we have the militarization of formerly civilian items like kites, balloons, seemingly what we would call innocuous items, but you can transform them into weapons. And the idea is that all of these are just examples, Uri, of the fact that our dispute with Hamas specifically has raised many issues which have caused people to say the law is not good enough. So my answer to them is that I would divide the answer into two. The principles of the law are good enough. The principles I went through earlier quickly, targeting, proportionality, lack of reciprocity, right of self-defense, these principles are equally applicable in any of these situations. However, the application in some of the new scenarios needs to be worked upon. You need to come up with more updated rules for the application of these principles in these unique circumstances.
Daniel, in the meantime, it seems that the International Criminal Court, the ICC, is sticking to the law, the existing law, and recently, even Fatou Bensouda, the chief prosecutor of the ICC, based in The Hague, announced that the court will proceed and investigate possible crimes committed by both Israelis and Palestinians since 2014, June, I believe. So we are faced here with a problem, because you say we are trying to stick to the law, and we're saying it should be modified, but in the meantime, we are faced with what the ICC is doing. So how do we counter it?
Okay, so first let me start by saying that with respect to the ICC, I'm not objective. In the current proceeding before the court in The Hague, I participated. So I was one of the 42 entities which submitted the amicus brief, friends of the court brief to the court with the court's permission in the ICC Palestine case. In that submission, I made it clear that I do not believe that the ICC has jurisdiction over these issues. And this was a position shared by actually all governments who participated in the process, including Germany, Austria, Canada, Australia, Hungary, and I forget the rest of the countries, but there was a list of them. So putting that aside, Uri, I think we face several different challenges. Now, I assume that everyone on this call either lives here or in Gaza. In other words, they know what's going on. So they will understand the complexity of the situation, and they will understand how difficult it is to judge legitimacy on the basis of what people tell you. The problem is, and this is a generic problem in international law, there are people who live outside the region who don't have the same perspective. Doesn't matter if they don't have the same perspective as the Palestinians or the Israelis, that's not the issue. And they try to make determinations on the basis of principles concerning which they have no personal or practical experience. And one of the issues, I'll give you one example, Uri, which I think is informative. There used to be a court called the ICTY, the International Criminal Tribunal for Former Yugoslavia. And they decided to prosecute a Serbian general for bombarding cities, towns, and villages, okay? And the court prosecuted, found him guilty of that offense because the judges decided that when he had used artillery against enemy units, he had used artillery too close to civilian towns and villages in violation of the 200-meter rule. which means that he fired artillery too close to civilian settlements. Now, he was convicted on this basis, but let me share with you something. There is no 200-meter rule. The court made it up. The court, full of judges who have no background in international law, they've never been on the battlefield, invented a new rule during the court case. Now, he appealed to the Court of Appeals, and the judges said, we have no idea whether these, they didn't say stupid, but they meant stupid judges, came up with the rule and they acquitted him of that offense. But this is a type of, this has nothing to do with Palestine, Israel, etc. This is an event which happened in former Yugoslavia. It goes to show you the issue you have when third parties with no practical experience try to adjudicate using rules that they have not used in the battlefield about situations they know nothing about. The good news is that this is not this group we are talking to now, Uri. So, because the people who live here understand the questions, the dilemmas, and the difficulties.
Right.
And that is an easier crowd to talk to. I have to share with you that when I talk to lawyers in Europe who have no idea whatsoever.
Daniel, a question just came in, but before I go to that, I remind you that Israel refused to cooperate with the Goldstone at the time, and then later there was some remorse about it. Aren't we doing the same mistake today by refusing to work with the court instead of boycotting it?
First of all, I'll take you back to the Goldstone Commission. It is true that Israel, let me remind everyone, the Goldstone Commission was established to investigate allegations of war crimes in, I think it was Operation Defensive Shield, right? Right. Many years ago. Now, the government of Israel, after careful deliberation, decided that because of the composition and mandate of the committee, it would not cooperate. You need to know, however, that during those 2 years, there were 16 international commissions of inquiry about the events. Israel cooperated with 15 out of the 16. The only one that did not cooperate was Goldstone because of the mandate and composition, which was biased from day one. So the story people are telling that Israel does not cooperate with international commissions of inquiry is false. It doesn't cooperate only with those which it sees in advance as automatically biased. Point two about Goldstone, in spite of what I said, there was one former senior Israeli who actually flew to meet the Goldstone committee and appeared before them and provided them with all the information. And how do I know that? Because it was me. And I flew to Geneva and I sat with them, and I will share with everyone here an anecdote. When they called me up to appear before them, I knew the government had already reached a decision not to cooperate. So I called up the government and I said, guys, I've been invited to appear before the Goldstone Commission. I heard I had just retired. I heard that you decided not to cooperate. What do you think? And they said, you know what? It's a good idea. That way we don't cooperate, but they do hear all of our positions. So it's a win-win. So I called up the guy who was arranging the testimonies on behalf of the Goldstone Commission, who was an ambassador in the United Nations from a Northern European country. And I said to him, I will be happy to come. And he told me that the hearings will take place in Amman, Jordan. And I said, absolutely fine. I've been there before. I negotiated the Treaty of Peace with the king. And I said, I just want to ask you a question. Will you be organizing a Jordanian security detail, or do I need to talk to the Israeli security services to give me a security detail? So he said to me, why do you need a security detail? So I said, I'm a high-profile Israeli colonel. I'm in the peace process, etc. All of the terrorist organizations know me. And therefore, every time we travel to one of the Arab countries, we get a bodyguard. So it's easy. They have a unit who does that. I've done it before. I can arrange it from the Israeli government. And then you know what he said to me, Uri? He said to me, Mr. Reisner, I have to share with you, this is the first time I thought of the possibility of an Israeli being threatened by an Arab.
Okay.
So I say that to you because that is part of the perspective problem that we face.
Daniel, questions are coming in. Can Israel be accused of acting against press freedom because of the destruction of a building in Gaza that international press offices were there, Al Jazeera, AP.
Okay, important question. And by the way, one of the questions I, of course, called the army to ask what was going on. The issue of targeting I talked about earlier is very clear. You can only target an objective, be it a building or an individual, if they are a military objective. So I was told, and I believe the people I talked to, that there was credible, powerful intelligence about the fact that that building was being used by Hamas intelligence as a headquarters. I've also read the AP response saying that they've been in the building for 15 years and they have never seen any evidence of such activity. And I tend to believe both parties. Personally, I think the AP people are telling the truth, and I think the army is telling the truth, which means that the Hamas people were keeping it quiet. Assuming that the army is correct, that the building was being used for military activities, whether or not the journalists knew about it, and knowing Hamas, that would be very much in line with the modus operandi of hiding military activities next to protected facilities, then the building was a legitimate military target. And the fact that journalists were staying there, journalists have no more protection in warfare than civilians. In that respect, you're not supposed to shoot any of them. However, journalists can become incidental damage, which is a tragedy just like civilians, but you do not get more protection because you're a journalist. If there was no military activity, it was not a legitimate military target. If there was, then it was.
There was a big if in your words, because you said that you believe both sides, and recently there was a complaint that the IDF spokesman has misled the press about potential incursion into Gaza. So are you still sure that what we hear from the IDF spokesman is the truth?
So I'll tell you, I thought about that story, and I also called up some people to try and find out what happened for my own personal interest, right? And I identified 2.5 scenarios, Uri, which I think you will recognize. Option number one, at the extreme side, is that the army decided to employ what we call a ruse of war, which is allowed in warfare, to lie to the enemy and mislead them, etc. It's basic, okay? But they decided also to mislead the media so that the Hamas would believe it more. This is not illegal, but this would have long-term impact on credibility of the IDF spokesperson, which would have a lot of negative effect, in my opinion. So it won't be illegal to do that, but it might not necessarily be a good idea. On the other side of the spectrum, we have what I saw the IDF spokesperson's position today, where he said, look, the international spokesperson misspoke when he spoke to the media, and he was misunderstood or used the wrong words, or etc., etc. And that is also a possible explanation. There's one in the middle, which could be that people in the army misled the IDF spokesperson and didn't tell them exactly what was going on as part of their own misdirection activities to make sure that the Hamas would know what's going on. I don't know which of these is the truth. Obviously, one of them is the truth. But I'll tell you one thing about the IDF spokesperson. I don't know this guy, but all the previous ones I worked with understood the basic principle of modern warfare, which is the war is taking place in parallel in 3 locations. 1 on the battlefield, which we don't need to explain, 2 in the international media, and 3 in the international politics. And if there's one mistake you should not make is sacrifice one for the other. So and all of the people I work with understand that you don't want to lose the international media war just to get a small advantage on the battlefield. It would be a totally stupid move. So in that respect, my belief is that probably the IDF spokesperson either was misled by what they heard was happening or made some type of mistake. That would be my guess, but I do not know.
I think it was Churchill who said that in war, truth has to be protected by bodyguard of lies. Okay, but that's Churchill. There's a question that maybe exceeds your legal expertise, and the question is from one of our from Paul. Do you agree that just because something is not illegal, there are many circumstances in which it is not moral, and sometimes often not strategically sensible, given that warfare relates to international and domestic political consideration and can lead to all kind of pressure and boycotts, etc.
So let me start by saying I think that's a very good question. And because Paul is also the only one who I can see his face, I can say it to his face.
Okay.
And I think we do need to distinguish between different components of a decision, right? First of all, legality. If it's illegal, it's illegal. It's a war crime. You're not allowed to do it, okay? So that is a hard stop. Then we come up to the next question. And when I was in the army, I always told the commanders, before you come to me with a request to do something complicated, first ask yourself the question, is it the right thing to do? Before you ask the legal question, you should say, is it the right thing to do? And when I say the right thing to do, it has certain criteria. A, does it make sense militarily? Is it really the right thing, or is it a response or reaction which is from the gut instead of from the brain? Two, is this something we will live with in 3 weeks? It makes sense today, but think in 3 weeks, the war is over, etc. Will you be sorry you did it? If you pass these two tests, then ask me the legal question, okay? Now, you can do it the other way around. You can ask me the legal question and then run the two tests. It doesn't matter, but I totally agree with Paul that any decision made in warfare has to look at these three separate questions, irrespective of legality. Legality is just one aspect. However, I do want to say two things about this. Military logic is something that military commanders understand more than me. In other words, sometimes because of they have intelligence and they know what the enemy is doing, etc., they will know about why this makes sense much more than someone looking from the outside. So it's difficult to second guess military logic. With respect to morality in warfare is one of those tough criteria, which, as I said earlier, I actually participated in a committee in the IDF before I retired, with the purpose of which to try to tie in morality to laws of warfare. And it's a very interesting subject, but unfortunately, we don't have time to go into it now. For me, the way I summarized it is what I said to you earlier. Is this something we'll be sorry about in 3 weeks or 4 weeks after the war? For me, that's my litmus test. And because I have been involved in numerous attacks over my career, approved the targeting, etc., I've had the opportunity to use this test and try and figure out what my rules are. But so I think, Paul, your question is absolutely correct. There will be activities which will be legal, but will be, in my eyes, you will be sorry you did them afterwards and may not make sense militarily. And my recommendation is, if you can understand that in advance, don't do them in advance.
Daniel Reisner, I want to thank you very much for your for this candid talk this morning, and we hope to see you again soon. Thank you all for being with us. This will go on YouTube a few hours later, so other people can watch it as well. Stay tuned to our next events and stay safe in the meantime. Thank you.
Thank you.
We hope you enjoyed that briefing by the Jerusalem Press Club. If you did, like the video and hit the subscribe button to stay up to date with all of our future content.